Day 2 of ASAP Rocky shooting trial.
I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. Well, I'm swallowing back.
Well, you're a good squabbler.
What up, TKG? We got it live. We're reacting, seeing what we catch as we see it. Let's get right into it. Hit the like button, comment below, let me know, subscribe.
Not speak to the press during the pendency of this trial.
Okay, I guess I'll start in reverse, John. First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case since the jury's been out. Never. Okay? But I do have here a quote from the district attorney, Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel's pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's their district attorney. Okay? So I should be able to rebut something like that. That's different. That's saying we're going to win the case, we know the evidence, and we'll meet our burden. I talked about nothing other than potential issues. I simply talked about the issue of the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. Try and get that message back to the jury that we're not happy with them. That is not the case. But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after a jury was impaneled. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. So again, the issue that I spoke about off record was caused by their late disclosure of a report that was generated over a year ago by their lead detective in this case. That Mr. Lewin wants everyone to believe he just stumbled upon 3 days ago. He just stumbled upon 3 days ago.
You don't have to whisper, just talk.
Try to get that middle ground there.
Just talk in a normal tone of voice.
That he just stumbled upon 3 days ago. He made all these accusations about that's disingenuous, I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case 3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
In
my view, nothing nefarious. I don't want to go over things that we've already gone over.
Well, we just did. We still have it.
He's asking that that both sides be directed not to make comments to the press. That's what he's asking for now. I'm not poking fingers. I'm not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to happen.
I have more things.
Oh, go ahead.
All right, I just listened to it.
Go.
Now, we heard all about the discovery issues, about this not being enough. I mean, I think this is incredibly detailed when it comes to Mr. Phillips, especially if this is a videotape. This is really detailed. Tell us what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside.
Based on what I've heard, I am satisfied, under the circumstances, that both sides have satisfied this discovery rules. So there's no reason to go over about whether you have complied with discovery. I already found that you did.
Okay, now I want to talk about Ben. There was a police officer, the first one out of the box, Sergeant Zizza.
Right.
The only thing we have from them, because, I assume the rules apply to both sides, right? The only thing we have from them is a few-line email saying we spoke to him on Wednesday. He testified Friday, recall. We spoke to him on Wednesday, and Jack, you have the email?
If you didn't catch it, they're going back and forth on who's leaking stuff to the press. Both of them saying the other side is doing it. Let's see if we can find out.
Here's what we have from them on Officer Zizzo. That they spoke to him on Wednesday, which the officer denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on and it's common occurrence that they'll receive a call to shooting and respond only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresenting. 2 sentences. That's the discovery. He testified that 1, he may have missed the bullet casings, and 2, he didn't know where to look. 2 sort of important things and he didn't agree, he didn't search the entire street. That was not in their disclosure. Not in their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in their disclosure that they interviewed him Friday before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or something. That was just about logistics. Okay, so before we start casting aspersions, I wasn't going to even raise it, Mark. Just happened. I understand this is trial. But, being that we're now throwing stones, let's call the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. Well, I'm swallowing back.
Well, you're a good squabbler. You're doing a good job squabbling.
They are squabbling on day 2 of ASAP Rocky trial. He's squabbling back. You heard him.
Did he write a report?
He did not write the report, Your Honor. But he obviously was wearing body worn video, which was
That's been provided.
that was provided
All right.
years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. It's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with that. I'm not even going to make the big. I'm not even going to raise the fact that he said he didn't speak to them on Wednesday and he only spoke to them Friday. I don't do that. It's petty.
It is petty.
But I want to make sure that what's good for the goose is good for the game. That when Mr. Phillips testifies and he says something, a word that's not in this thing, it's not like, you didn't tell that to the lawyers. It's just not right. This is not a transcribed statement. There will be nothing outside of the scope of this. But the same way I didn't get anything from them regarding, I may have missed the showcases. I didn't get a report that said that first thing.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they follow that rule. But what I am concerned about is someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So, here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you can call it a gag order.
We will advise, obviously, the courts where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's published report where he dared, quote, Nathan Hockman to try the case himself. But we're going to tell the DA.
Let's move forward. Yeah, just let everybody know in your office who may say something. Tell them not to say anything to the media or the press.
Will do, Your Honor. We had 2 last issues which are brief. The first issue is we're going to request, we made this request before. Counsel and I've tried many cases in front of the court. If there's anything even close, I 402 in advance. If there's any evidentiary issue, which is even a close call, in terms of the defense introducing, bringing up, asking a question, we want to make sure that they ask an approach and that we 402. You don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, as the court is aware, on Friday,
They squabbling on day 2. Hit the like button. Comment below. Let me know. Subscribe. Road to 100,000 subscribers. Till next time I'm out. Peace.